In the month leading up to filing, my client became inexplicably ill. And initially, the doctors thought he was going to die, fitted him for a colostomy bag. After 4 days in ICU, his numbers were nearly normal. To date, we have no idea what poisoned his kidneys. And as soon as he came home from the hospital, Ms. Calloway moved out and the divorce was filed. Since that time, he's had no health problems whatsoever. We have a technology problem that makes him across from me, but if you need him, I'll turn the camera.
No, I just wanted to inquire so I could note for the record his presence.
Yes, Your Honor.
He appears with his attorney, Julian Thomas, in her office. Nana appears with Ms. Orchard in her office. Everyone is appearing by Zoom. We are scheduled for a pre-trial conference, and frankly, counsel, I'm disappointed to discover that this case was announced as resolved or nearly resolved. We've had prior settings that were moved because the court believed the case was resolving itself. And now apparently it's fallen apart, and there are allegations that there were non-disclosures or non-disclosure of a substantial asset. And now I have pretrial orders from you, which indicates to me that, or pretrial questionnaires that indicates to me that you're ready to put an order together and you want a trial date, which again was not the direction that I thought the parties were working. And had I known that was going to be the case, I would have made everyone appear previously and I would have put some things on the record. But at any rate, we are where we are. I need to address a motion that was filed by the petitioner for bifurcation, and I received a response to that motion on the 23rd, so Wednesday. Let's see, the motion itself, well, I had it in here. Yeah, there it is. Was filed on March the 12th. So that was a while ago. So do you need further argument on the request for bifurcation?
I do, Your Honor.
Okay.
Would you like me to proceed?
You may proceed, Ms. Thomas.
Thank you. Your Honor, this case was filed in February of 2024, which is more than 14 months ago. My client is 68 years old. For a significant period of time prior to the filing, the marriage was irredeemably broken. In early 2024, he had had cancer. That cancer was removed. He's now cancer-free, and that health issue is resolved. But it was during that time that he learned that a divorce was likely inevitable. In the month leading up to filing, my client became inexplicably ill. Both of his kidneys failed. The toxicity of his kidneys should have been at 1 or 2, and they were at 11. He was admitted to ICU, and initially the doctors thought he was going to die, fitted him for a colostomy bag, and were just trying to figure out what was going on. No test showed anything. No doctor could figure it out. After 4 days in ICU, his numbers were nearly normal. The doctors called his recovery amazing. They kept him to watch him for 2 more days and sent him home. To date, we have no idea what poisoned his kidneys. He sees a kidney specialist every 4 hours. Nothing has recurred with that. And as soon as he came home from the hospital, Ms. Calloway moved out and the divorce was filed. Since that time, he's had no health problems whatsoever. But Your Honor, he's 68 years old. In this case, there are sizable premarital assets. He worked and saved well prior to the marriage. There are also sizable marital assets, which we believe all marital assets are to be divided 50-50. If he, after 14 months with this health history, if he passes while married, all of his estate, including all of his premarital assets, will go to his wife as his heir. He's under a temporary order that restrains everything. What we are asking I believed we had the case settled. I believe counsel believed we had the case settled. Today, I am hopeful that we will be able to seriously curtail through stipulation what the issues are that will be before the court. But I am 90% certain that we will not be able to settle without hearing. And I feel 100% certain that if we settle, it will be the day of trial. Counsel, I think, will suggest that bifurcation disincents settlement. I am suggesting that bifurcation incents settlement. And here's why. If I am on a case where we have this health history and I have trial coming, and if I'm a widow, I take 100% of everything, I might feel disinclined to take half of marital assets. Wait until the time of trial, because it's more financially advantageous to be a widow in that situation than it is to reach a settlement. So this is what we are asking. Given his age, given the fact that the case is more than a year old already, given that, to not bifurcate and allow him to enter estate documents for whatever Your Honor would assign to him in the future functionally causes him to disinherit his children. They have a child together, but he has a child outside of the marriage who's an adult as well. So we are asking for, please bifurcate this action today. Please reserve jurisdiction to enter all property and custody orders that are not resolved as of the time of trial. Please allow my client to update his estate planning documents so that whatever you were to ultimately award to him or he took by agreement could be passed to both of his children, not just to his estranged wife. So it's three things: bifurcate, reserve jurisdiction, and allow the new estate documents, Your Honor.
Well, let me ask you a few things then,
Okay.
instead of putting your client under oath.
Okay.
So it's fine for you to say that she's disincentivized because she's better off with him dying than getting divorced. But you should be able to point specifically to things that she has been doing to intentionally delay this matter in some way for the disposition of it or resolving it. It's not good enough for me because I am a judge who does not bifurcate. I do believe parties work harder when they want to be divorced to get all of the loose ends taken care of. And I do think they're disincentivized. And the only time that I bifurcate or even grant emergency divorces for that matter is when there is a financial situation that is very apparent that's going to be detrimental to both parties if they're not divorced, or there is a legitimate pre-existing disease or illness that is being exacerbated by the divorce proceedings themselves. Not just nervous anxiety and things that develop from getting a divorce, but some kind of disease that is chronic in nature. So that's just so you know, my theory as a judge, that's my general theory as a judge. So you just saying theoretically she has no incentive to settle is not good enough for me. You need to tell me that all of these continuances and these delays have been caused by her, and there's evidence that it's intentional in nature to obtain the result that you're alleging is the basis for bifurcation.
To do so, Your Honor, would require me to disclose settlement negotiations, and I can't do it. So what I can say is I believed we were settled. We would still sign the settlement that I believe existed, and we will not, and we will not agree to, just at a very high level, because I don't want to get into settlement negotiations, to disparately treat assets, which was not part of the original settlement. And I want to address, Your Honor, this accusation about there's an undisclosed asset. What happened was, I'm not the first lawyer on the case. My client filed for divorce and under the advice of prior counsel, and I have confirmed this not only with my client, but with prior counsel. He was advised, You see, I'm walking in dangerous territory. When he filed, his assets were all in one format. He changed the format of his assets in a way that I could not figure it out. He could not figure it out. That was not a concept that where did you work at? Boeing? Is that right? Yeah. He was on Boeing and Spirit on the line. He's not a financial advisor. He's not a CPA. He's a straightforward grassroots guy who's putting money in retirement. All of the assets changed forms, and it was pandemonium. And I got a file. I'm trying to figure out where everything is. And I'm saying, why in the world did you do this? All I can say about that was it was not his idea, and it wouldn't have happened in my case.
Okay.
We then provided a bunch of discovery through prior counsel and a bunch of discovery through us. And at the last minute, before we settled, but after we had completed discovery, we learned there's an asset out here. The case was in pandemonium. As soon as he learned it, he told me. As soon as I learned it, I told counsel. So it is true that it was not disclosed in discovery. It is also true it was disclosed before settlement. I can't put where it was awarded, but certainly it was in the marital estate and assigned fairly within that. And so it is not a matter of my client nefariously is trying to hide assets, but there was one late disclosure that was disclosed before the settlement and dealt with the same way everything else was. After we had that settlement, the settlement blew up. We will still accept that settlement. That settlement is still not on the table. Yesterday, I received another offer of settlement. I was seeing my client today. I've been trying to talk through that and work through that. And next week, I will respond in writing. I believe we will be able to stipulate to almost all of this case. I believe Your Honor will have to decide if assets are to be tax treated when those gains are not being realized. I believe Your Honor will have to decide whether that application is disparate or equal, because I don't believe we're able to settle that. And across.
Are you going to have a tax there, either his accountant or a tax attorney or someone as an expert to testify for the court?
My position is that unrealized gains are not tax treated. If we're living in a house, I don't say, well, we've got an appraisal, but I'm taking off 6% because we might sell it someday, and I'm taking off 3% because maybe that's closing costs. I think unrealized gains are not tax treated across my 30 years of practice. And that's going to be my position. So I'm not bringing someone to guess.
What do you mean by tax treated?
If I have a house worth $200,000 and I have a retirement account worth $200,000, and my husband and I divorce, my husband takes the house and I take the retirement, but I'm still 15, 20 years from retirement. I do not believe that the court is going to, and I could be wrong, but I do not believe that the court is going to say, we are awarding you the house at 200, but we are making up how much tax might be applicable in 15 years. So now you're not taking a $200,000 401k, you're taking a $178,000 401k because we've arbitrarily applied tax treatment.
Yeah, I guess I've not seen lawyers that good. I'm sure there are that astute in tax law that they go through all of the assets and add or subtract tax implications for the equality of that. I've never seen that done. I mean, I think if you know you've got something that is going to be assessed capital gains, whether it's, or you've got some kind of stuff. I mean, if you've got to liquidate something that's very clear that somebody's going to have to pay taxes on it, that's right. One. However, I will say, unlike a lot of judges, if people ask me to value a house that's being sold or something of that nature, and there's not a lot of equity, I will often offer the suggestion to them that they should subtract 6% of the value of the house, right, because you're going to spend some money getting it ready to sell, and you're going to have to pay a real estate commission. And oftentimes that's completely ignored, but not if someone's retaining the house, because we all know real estate's the one thing that generally increases in value with time.
And that, Your Honor, is all my trial position. What you just said is my understanding of the way it will be. So I am not agreeable to tax treat because there are no realized gains that we're dealing with. Nobody's selling anything. They just exist.
Is there some new legislation or some new ethics class or some new thing that lawyers are being told this has to be part of the, I mean, I'm not saying it's unwise. I'm just saying, this is not really a legal opinion. This is just my experience that I've not seen lawyers astute enough to be able to do that across the board.
And that would be a question for Ms. Orchard because my position aligns with what I'm hearing you say, Your Honor. I don't know of a reason to do that.
I have two more questions for you about your client, though.
Sure.
First of all, does he not already have an existing will?
Do you have an existing will? Do you have, excuse me one second, Your Honor, let me ask. Yes, Your Honor, he does.
Well, I mean, I just can't imagine a situation that if he died, it would cause his child from a previous relationship to be disinherited. I guess that's what I'm not, because by law, that child would receive, and I can't imagine him doing a will where he didn't include that child. So I'm not quite understanding that concern, but
she has a spousal elective share, Your Honor, after 30 years of marriage of 50%.
I understand.
Okay.
But that doesn't mean that both children aren't going to share in the remainder equally.
Okay.
So, yeah, and that's the other thing. I'm not sure what all's premarital. Maybe you've identified it in your pretrial when you've got a 30-year marriage. I mean, this is a pretty long-term marriage. This isn't a,
right.
Married for 30 years to someone and then married someone for less than 10 and have a child with them where they've accumulated the majority of their assets prior to entering into this second marriage. But I don't know a lot. And of course, I'd have to hear evidence on everything. I understand your position. I'm more inclined to get you a very quick trial date. But okay. Here's my question. Is discovery complete?
Yes.
Ms. Orchard, do you believe discovery is complete?
Well, Your Honor, as far as what you just said about premarital assets being identified, they're not. Subpoenas were issued by Ms. Thomas in October, and to my knowledge, we still haven't received anything from those. From a conversation with her, she told me she didn't really intend, we thought we had a deal, but since then, so as far as discovery that I want to issue to her, yes, that is completed, but I think if and it looks from her pretrial questionnaire like she intends to get the results of those subpoenas to identify premarital assets, then I don't think we can have a quick trial. We don't have them yet, and I can't agree. The burden is hers to show that stuff is premarital. I can't agree to anything when I don't know what the numbers are, unless I can agree to a 50-50 split. But if she's wanting to take out these numbers, I need to see them. So that's my only hesitation with a quick trial date. But otherwise, that's fine with me.
Well, you both sound real reasonable when I hear from both of you, but for some reason, when you come together, it doesn't apparently work out that way. Let me get my calendar just a minute.
About 8, 9 years ago.
Your Honor,
So, Ms. Thomas, I'm not trying to be callous. Does your client have a letter from a doctor that states that he has some kind of current situation that makes him very fragile, or I'm trying to think of the word, that he's quite susceptible? There's a probability that he may pass shortly. I mean, anybody can be hit by a bus and any one of us could die tomorrow. I mean,
Right.
that's true for any divorce.
Right. In the year leading up to filing, he fought and survived intestinal cancer, and he was in ICU with a toxicity level in his kidneys of 11. So I have not gotten a letter from a doctor to confirm that whether that doctor interprets that as making him a fragile health.
Okay.
I can get that letter. I feel confident, but I have not done that. And Your Honor, before we schedule a trial date, may I ask for clarification on something?
Sure.
So we have spent tens of thousands of dollars on a case that, in my opinion, is the easiest case to settle that I can possibly imagine. And one of the issues there is there's about 15 years of premarital contribution to retirement accounts. And then there's about 30 years of marital contribution to retirement accounts. My client is retired. And the way that I have approached that over the scope of my practice, and I need direction from you whether this is appropriate in this case, is...
Your Honor, I would object to this. I mean, we're just doing nothing but advisory opinions today. This is not the trial. She's just asking for your blessing on her positions for trial. That makes no sense.
Your Honor, I'm asking.
I understand, and I'll be careful with how I answer this, but domestic law has very few cases on appeal because it's so discretionary, and it can vary so much from judge to judge unless there are actually rules that are adopted by the district that give direction. And that includes everything from spousal support. The only thing that's very clear cut is child support. Unfortunately, everything else is subject to the philosophy or the discretion of a particular judge. And I understand that no one has an advantage over anyone else if they haven't practiced in front of a judge with a specific issue of very recent. And every case is case by case, but I'm going to allow her to just see if the court has a standard position on how it's approached, not how I would rule at the end of the day, but what my starting point is.
Thank you, Your Honor. So my question is this. With that premarital contribution, the way that I have approached, so I subpoenaed all of the statements as of the date of marriage, and that was going to be the breaking point. I moved offices. They were sent to my last office. They were sent back, and here we are. So the way I have approached that, which I've approached it in many cases, but I don't know if it's appropriate within your courtroom, Your Honor, is everything as of the date of marriage, I am taking the position was a premarital contribution. Everything from the date of marriage, I am taking the position as a marital contribution. If Your Honor needs the exact number of what that was, then I will need to resubpoena those documents to submit them, and Ms. Orchard is right. If I am allowed to take the position of whatever it was as of the day before marriage, is that premarital? If it is, then it goes to him. If it's not, it's divided 50-50. So the question is, do I need to reissue those subpoenas so that you know what the dollar amount is? Or can we talk about dates, and whatever those dates are, you will decide if it's premarital, it goes to him. If after 30 years it's marital, then it's divided.
Yeah.
So do I reissue the subpoena is the question.
Well, unless you're going to do a quadro, which just directs the time periods, then yes, you have to have the actual numbers.
I'll just get the numbers, Your Honor, which sets out the trial. Yes, I was going to do quadros that would say everything as of X date 1997 stays with him. Everything from the day after that going forward is divided 50-50. To me, I don't care what those numbers are, but maybe now that we're going to trial, I do care what those numbers are. So I will subpoena those. I will issue those subpoenas on Monday. Ms. Orchard, if you could advise maybe by email later if you will waive the 10-day notice, I would appreciate that. And then I will know to the nth degree exactly the dollar amount instead of the date.
sometimes it's just not a matter of people being difficult. I understand it's a matter of attorneys making sure they've fulfilled their responsibilities. And so I think you understand that as well.
I do.
All right. So today is the 25th.
Your Honor, may I ask for clarification quickly?
Yes.
What was your ruling on the bifurcation, just so I know whether I need to respond or not?
I haven't ruled yet.
Okay, if before you do, could I please respond?
Oh, yeah, absolutely.
Okay.
I could do Monday, May 19th, 9 to 5.
It's not enough time for me to get my subpoenas back, even with service, with a
Okay.
notice to object waived, Your Honor.
Okay. I could do Friday, June 6th, 9 to 5.
Fortunately, I have a child in need care trial that day. Sorry.
Okay. I might. This would not be a prime setting. It would be an alternate to a jury trial. Amy, where you wrote, let's see, we have 1, 2, 3, 4 cases scheduled for jury, correct?
On what date?
I'm sorry, on June the 3rd.
Yes, there's 4 of them.
And on each one you've written 3, like 3-day trial. Is that because they've given an indication they will probably take 3 days, or you just always block out 3 days?
No, the 3 days is the amount of days that you had indicated when the trial was set. And every single one of those cases are Watts.
I could set you as an alternate Thursday, June the 5th, all day from 9 to 5.
I'm in trial in Sedgwick County that day, Your Honor.
I don't want to, but I could set your case on Monday before my jury trials. I usually like to get ready for those, but I could do it June the 2nd, Monday, 9 to 5.
I feel concerned because when I issue my discovery, it will be April 28th. And if someone does not timely, even if I get it back within 30 days, even if notice is waived, which I don't know if it will be, it's possible that I just will not have the discovery and won't be able to process that into exhibits that we exchange in a timely fashion.
Sorry,
So
I lost everybody. I could do it Monday, June 2nd, 9 to 5.
Your Honor, Ms. Orchard, do you have an opinion about whether you are going to waive the 10 days?
Yes, I waived them the first time. I'll waive them again.
Okay. If I prepare that discovery Monday and serve it Tuesday, that gives the people receiving it until the Thursday before trial on Monday to respond. If any one of them fails to timely respond, I don't have any time to address that. And I don't have any time to process it because we're going to have to exchange exhibits.
Okay.
So I think we're going to have to set it out at least until the week of June 16th in order to give me 2 days to file it, 30 days to receive it, and then 2 days to make sure I've got it and process it.
Amy, I'm sorry. Was there a case that we settled yesterday that has been scheduled for trial that came off the calendar?
Yeah, but it was in May.
What date? Oh, yeah, May too soon. That's May too soon. It's too soon.
Yeah, it was the 22nd though, but you already put another case there for trial that afternoon. yesterday.
And so Jardo is the one in Greenwood County that the lady's coming from Washington State, the
Yep.
16th and 17th.
I've
And
got
then
Dana.
the City of Andover versus Miller, they announced is still for trial.
Yes, but the only thing on that one is the day that you had set the Jardo case, you had moved the Andover case.
To the
Dropped
afternoon.
it down and dropped it down to a half day. I did email them that day to inquire if they were still going to be requesting 2 full days and if it was still anticipated to go to trial, and they said yes to both of those. So I haven't addressed with them that they've lost half of a day on that case yet. So I don't know if that case is going to have to be moved or not.
The problem is that June 19th, right in the middle of the week. If we could
Yeah.
utilize that day, I wouldn't have any trouble.
Right.
So, okay, I'll figure that out later. So that week's out. And the week of the 23rd is my criminal docket week. That's all week long, every day criminal matters. So then I have June 30th.
I can do June 30th, Your Honor.
Amy, I know that's my duty day and I would have first appearances that I would have to cover. And then we start trials on Tuesday, July 1st, if we have any. I wrote EK appearance. I don't know what that is. Do we have an Elk County appearance at 9 a.m. on June 30th? Or what? EK.
Unless it's something from the judges meeting on maybe potentially covering Webster. That's the only thing that I can think of. But she doesn't have any Elk County stuff, so.
Right, would it be Joe Lee that I'm covering first appearances for him at 9?
He has Elk County first appearance dockets at 11:30, and then Webster has a misdemeanor control docket for Butler at 9. I don't know anything about any Elk County stuff.
I don't know
that day.
I don't know what I did. I don't know what that little note is that I made.
No,
I
no.
also have July 7th. So I either have June 30th or July 7th. They're both Mondays. Or I have Tuesday, July 15th. That is a criminal docket week, but I have nothing on Tuesday that day all day. Those are 3 dates I can give you. June 30th on Monday, July 7th on Monday, or July 15th on Tuesday.
I can do June 30th on Monday if council's available.
Yes, that or the 15th work for me.
And do you need to start at an alternative time, Your Honor? Was that what?
No, I'll start at 9, but if I can't get another judge to cover first appearances, I will have to take a break from 1:30 to 2:30. So I might just have you guys bring snacks or something to get you through to a 1:30 to 2:30 lunch hour would probably be the best thing to do. Unless somebody has sugar issues or something, we'd take lunch. And then I would have to take an hour break to do first appearances.
Okay.
So, but otherwise, you would have the whole day. Okay, I'm going to schedule this case for trial Monday, June 30th, 9 to 5. I am going to schedule another pre-trial conference at 4 p.m. on June the 12th. For an order, please. Which
I'm
should
sorry,
be-
what did you say,
be
Brenda?
too hard to do since you have your questionnaires completed. Do what?
I'm sorry, Your Honor, you're saying just file a joint pretrial order
Yes,
on that day, but is there an appearance with that? I'm sorry, I'm just
not if
unfamiliar.
it's on file and you don't have any other pretrial matters to take
Got it.
up.
Thank you, Judge.
Okay, Ms. Orchard, I will hear you on your response to the motion for bifurcation. And it's not just a motion for bifurcation, it's a motion for bifurcation and to allow him to potentially make changes to his estate planning.
Well, Judge, I would disagree with that. She did not put that in the motion. She raised that today. So I don't think that she's properly notified me of the intent for him to change his estate documents. And as far as my client is concerned, she's not aware of any estate documents. So if he does have a will, I would love to see it. Because she told me she didn't think he had one. So her motion was just for bifurcation and for attorney's fees. So to ask to change his estate documents today, I think is highly inappropriate, given that we don't even agree on whether there are estate documents. As far as the bifurcation goes, I've been on this case from the beginning. I will admit that a lot of the delay at the first half of this case was not Ms. Thomas's fault. There was another attorney on this case. I had to push then quite hard on a lot of things. Discovery was overdue. I had to do golden rule letters. I almost filed a motion to compel. At the time I was going to file a motion to compel, he got a new attorney. And so then she asked for some grace and extended time. Instead of filing a motion to compel, I'm new on this case. Can I get some more time? I said, of course. I granted extended discovery deadlines for stuff that had been pending for months. And it took quite a long time. We did eventually get discovery exchanged in full. And then there were still issues about the retirement. So she issued those subpoenas in October. I understand that she didn't get them for something that was maybe not her fault with the office changing and all that stuff. I'm not saying that, but the fact is I still don't have those numbers. Even then we proceeded with negotiations. We had a settlement conference, and then at the settlement conference, I disagree that this was something that was disclosed prior to that. I don't think there's any more that we can do other than just say we have a factual disagreement that this asset was disclosed. So of course that changed things. And I will say she did not immediately notify me when she found it. She slipped it into the documents and sent them in January with the new offer. Didn't call any attention to the fact that this was something that was different from the last offer or the deal that we had to now. So I think the delay in this case is entirely on the petitioner. And I don't think it's fair to grant a bifurcation, which does disincentivize him. I agree with you, Judge. It does not disinherit his children, whether he has a will or not. I don't think it does disinherit. And her forced share, if he doesn't, is 50%, which is what she's getting in this divorce, or what she should be getting in this divorce. So I don't think that there's anything wrong. What it would do if you grant the bifurcation and he does pass away would make a messy estate. She has to then file a claim on the estate for her portion. And it's just, that would be more of a mess than if he were to pass away while this is pending. And from her argument today, I don't think there's any credible belief that he has any more reason to think he's going to pass away than the average person does. So I don't know, we can't just bifurcate cases because they've taken a long time when that delay has been faced. My other issue is if he does have a credible threat that he's going to pass away, or credible belief that he's going to pass away, and you asked for a letter, she said she could get that, then I'm confused why she's asking to litigate custody and ask for shared residential custody of this child, which has not been what we've been doing under temporary orders. And we're going to go to trial and he's asking for shared, but we need to bifurcate because his health is such that he might honestly pass away in the next few months. So so many things don't make sense about this to me. I don't think it's fair to bifurcate. I certainly don't think it's equitable to order attorney's fees when a lot of this delay has been on him. I asked that we reserve the issue of the attorney's fees that she's asking for to trial, because after we make a ruling, you make a ruling on the divorce part of this case, you could then hear our settlement negotiations and determine if his request for attorney's fees is valid. But I think it's inappropriate for you to hear our back and forth before when you're deciding. So I think that should be something we address either at the end of trial after you've ruled on the divorce. We could present more evidence then, or we could set it for another date. that I think to take up that issue right now is just, I don't think you have the information you would need, and I don't think we can ethically give it to you at this point. So that is the response for the bifurcation motion. As far as the pretrial conference, I do need clarification from you. Are we going through our pretrial conference questionnaires at this point today, like we usually do in a conference hearing, or are you wanting to do that?
No, because we didn't have if we had an impending trial date soon, I would, but since we're just now scheduling a trial date and we have time to do one 14 days before the next trial, then I'm just going to have you two come up with a combined. Obviously, if you don't come up with a combined, then we're going to have to do that. It's going to be close to the trial date, but I'm confident that you two can put together an order, and then you don't need to appear either if you don't have any, motions before the court or anything related to trial issues. So I am.
May I respond, Your Honor, briefly? I withdraw my motion to modify my estate plan. I am not saying he's going to die. I'm saying after cancer and kidney failure, I think a doctor would probably write a letter that the stress of ongoing divorce and all this anxiety isn't good for him. And I agree we should set the fees over to the time of trial.
Perfect. All right. So I'm going to reserve ruling on the fees. I'm going to deny the bifurcation today. What I would need to reconsider my ruling is something from the doctor that says we've done a recent kidney test and his kidney is not functioning properly. We've discovered that he may have cancer in another area. I mean, it's not just, I'm just not finding that one or the other is intentionally causing delay. I agree there may be delays, and I think Arlene Burrow was the attorney to begin with, and often when you change attorneys, there are issues, and often when an attorney changes office, there can be issues, and certainly I'm not criticizing any of that. I would only be speculating as to why this agreement that you two worked so hard on fell apart. So I can't blame any one person for that. But, I really would need to find, to me, bifurcating would be saying, in a way, I'm going to punish the person that is making things difficult and doing it for their personal gain. And I just can't make that finding today. But I am not going to disregard the fact that he has health issues. And if he's had some recent testing done that has put him in a situation of alarm, that that he could be hospitalized before trial or take a downward turn, I'm going to change my position on that. But I just don't feel like I have anything concrete enough, that's also including given my basic philosophy about bifurcation into consideration as well. And I know you weren't necessarily aware of that.
I was not, but thank you, Your Honor.
Okay. Well, I appreciate both of your time. We've got a trial date. I think you're both on top of your cases. You know what needs done. You're going to get it done. And one way or another, things will get concluded, before the end of the summer, for sure. Okay.
Thank you, Your Honor.
All right. Thank you very much.
Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill. Based on her representations to Mr. Murphy would be dying within the year. Now he is being told by her numerous friends and family that she is not in fact terminally ill, nor was she ever terminally ill. She continually stated that she was fatally diagnosed.
Even if you believe that there was a diagnosis, now the complaint is she didn't die.
Kimberly Taft versus Scott Murphy.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff and Ms. Capture on behalf of the defendant. This matter is before the court on the defendant's motion for relief from judgment. Ms. Capture.
As we stated in our motion, Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill, and based on her representations to Mr. Murphy would be dying within the year. The agreements that he agreed to essentially are unconscionable, especially given the fact that there is a massive divide between Mr. Murphy and the children now. He doesn't have the parenting time that he would have wanted, but obviously gave more parenting time to Ms. Taft, given her assertion that she was dying. He wanted to keep things as even for her. Even isn't the correct word, but essentially he wanted to make sure that she would have a decent rest of her life. So they didn't divide the business. A lot of the things that they kept around, like the country club dues, the tickets for the baseball and football or basketball and football games. Essentially he agreed to this on the understanding that she was going to be passing. If she's not, and he has tried to communicate with her and say, hey, what's actually going on? Because I'm being told that you aren't terminally ill, and that you induced me into agreeing to this agreement without under a false allegation. So essentially, Your Honor, what we're asking for is an evidentiary hearing so we can put proofs on the record to say Mr. Murphy did enter into this agreement under duress, that he believed false information presented by Ms. Taft. Even within his pro-con, he stated, and I'm not going to quote this directly, but he stated an understanding that he was entering into this agreement due to her terminal illness. Without counsel, without representation, and simply signed the dotted line due to the misrepresentations that she placed to him. So, Your Honor, we're looking for an evidentiary hearing to prove that misconduct did occur, and then to move forward with this matter. Thank you.
Thank you. Mr. Schaefer.
Your Honor, we have filed an extensive answer to this. Number one, we submit that this is an improper motion for a number of reasons. Number one, the allegations alleged that my client said are not true. Next one is that it's pretty clear that it's under duress, pressured based on the allegations therein. Number three, this was filed because my client hasn't died yet. Well, they didn't give her a year. It's February 29th judgment. I represent to this court melanoma. It's in remission at the present time, and to see that there's something inequitable about this. What is improper on this is that counsel for the other side signed these pleadings knowing that the business was owned by both of the parties. We have submitted evidence of that, and this was filed just before there is a oppression suit that is going to be filed in relation to the division of the business. Client is asking for costs and sanctions in that regard because both the client and the attorney signed pleadings knowing that there's a 50-50 ownership in the business. My client has never used her melanoma in any way to affect judgment. It was a choice by the defendant not to be represented. He had been represented around this matter and chose not to. That was his decision. Now he is crying sour grapes. His allegation about the children, his relationship with the children at the time was poor at best and did not exercise his parent time at this time. We submit that this motion is unfounded in fact and law, should be dismissed, and that costs should be assessed in relation to the improper pleadings.
Thank you. Anything else, Ms. Capture?
Your Honor, The pleadings aren't improper. Again, this is not so much about the allegations that this is a jointly owned business. We admit in our motion that there's a marital interest in this. Again, Your Honor, this is simply about the misrepresentation by Ms. Taft that she's terminally ill. She induced my client into signing a divorce decree to get this settled so that she could live in peace the last time, however long it was going to be. Mr. Murphy has requested on numerous occasions, can you just communicate with me about what's going on? And she refuses to. And now he is being told by her numerous friends and family that she is not in fact terminally ill, nor was she ever terminally ill, and that he agreed to this under the misrepresentation that she was. Again, Your Honor, we state in our motion specifically that we are just simply asking to have all of this resolved. However, Ms. Taft will not communicate. And if she is going to continue living, which is great, good for her, we want her to be in remission, we want her to be healthy. But if she's going to continue, obviously the marital property needs to be divided appropriately, including the business. That's not to say that we are saying, well, we shouldn't ever divide the property. We simply need an answer, and we need the correct answer, not a lie. If she's going to be passing on, well, then let's get that resolved, and we would withdraw our motion. But we obviously, she's in remission, allegedly. So then she obviously didn't have terminally ill melanoma like she represented to my client.
Well, in this matter, the court does note that fraud has been alleged, but as I go through the pleadings here, the argument, there's been very little factual basis for the allegations. I don't believe that in this matter, the defendant has set forth a prima facie case for the court to again intervene at this time. And so the court believes that if in some time if the defendant can develop those particular facts, then the defendant can file an amended motion in this matter. But at this point, the court doesn't believe that there's a factual basis in this matter other than a he said, she said. And as a result, the court will deny the motion at this time. And the court doesn't believe there's a basis for award of costs or fees. So it will deny that request by both parties and ask Mr. Schaefer, you prepare the order denying the motion.
I will, Your Honor. Thank you.
You're free to go. Have a good day. This matter is before the court on the defendant's amended motion for relief from judgment and motion to modify judgment of divorce. Court notes I have received and reviewed the answer as well in this matter. Ms. Capture, you can proceed.
Thank you, Judge. First and foremost, I just wanted to be stated for the record that we came before this court a few months ago on our original motion to set aside the judgment of divorce.
Ms. Capture, I don't want to interrupt you, but you don't have to give me all the background. I'm well aware of it. I've reviewed the file in preparation for today.
Thank you, Your Honor. I just, all I want to say is that my client would have no reason to say what he did at the pro confesso hearing if not for the 2-hour, 3-hour conversation that he had with Ms. Taft discussing the terms of the judgment of divorce, where she continually stated that she was fatally diagnosed. Again, Your Honor, we've been here before. I've stated this before. I wish no ill will on Ms. Taft. However, the fact of the matter is that my client entered into a judgment of divorce under the presumption that circumstances would be different at this time. Also, I just want to address specific things stated within Ms. Taft's answer. While she states that she never directly told Mr. Murphy not to have an attorney, she would often utilize the children. She communicates through them very frequently. She utilizes them to induce Mr. Murphy into complying with what she wants. So for instance, she would communicate that, Mr. Murphy shouldn't have an attorney, and they would talked to their father stating, you know, we're really upset that you have an attorney. You should get rid of one. Mom already has an attorney. She also utilizes them when it comes to parenting time exchanges. She will initially try to communicate with Mr. Murphy. If he doesn't agree with her, she will then communicate with the minor children. A great example of this is an exchange location. Recently, the parties were trying to exchange the minor children. Ms. Taft violated the agreement twice. Mr. Murphy then stated, well, I'm not going to go by your agreement then if you're not going to follow it either. Then Ms. Taft called the minor children, who then coerced Mr. Murphy into, or convinced Mr. Murphy into going by the agreement. This is a repeated action. Unfortunately, these minor children are being caught up in divorce and post-judgment proceedings because Ms. Taft continues to include them in this. For instance, as we stated in our motion, Mr. Murphy has continually tried to work with Ms. Taft. He did not get the overnights on 6:30 through 7:2, 7:7 through 7:9, 7:14 to 7:16. Even though it's stated in her answer that he did get those, he didn't. He was trying to work with Ms.
I want to interrupt you now, but how does this go to your motion? You're bringing up all this extraneous stuff. Doesn't go to your motion to set aside the judgment.
Well, Your Honor, our motion is to set aside the judgment and in the alternative to modify the judgment of divorce pursuant to all the reasons stated in our motion. The first portion of our motion is to set aside pursuant to our original motion that we filed. And then the second portion is to state that in the event that you don't want to set it aside, that we at least modify it to comport with the changes in that Ms. Taft has not complied with the parenting time agreement, has not complied with the expenses agreement, which Ms. Taft states in her answer that it's actually Mr. Murphy that keeps shutting off the card. In fact, the agreement by the parties is that they utilize that credit card for all extracurriculars, and instead Ms. Taft charges her personal cell phone, all the groceries and gas on that card, and frequently maxes it out, which is why it's allegedly being shut off. So, Your Honor, again, there's numerous inaccuracies stated in this answer, and so we're asking for either the judgment of divorce be set aside, or that we modify the judgment pursuant to our requests to incorporate the changes that we need. Thank you, Your Honor.
Thank you. Mr. Schaefer.
Your Honor, this is a motion to set aside the divorce judgment under Rule 2.612. And it certainly goes astray in a lot of ancillary ways that I don't think are relevant to that issue. Our position, there was no pressure. How does one pressure somebody not to have an attorney? And then we hear today new information not pled about influencing through the children, which is not supported in the pleadings or anything else. This is a remake of the prior motion. There's no new information herein. The only thing that they attached was the testimony from the pro-con. And again, the judge recognized that. The judge indicated that he was convinced that he approved the judgment, he understood it, and he signed it. This is an agreement that they negotiated, that it went into effect, and there's nothing in here of any sort of fraud at all. Even if you believe that there was a diagnosis, now the complaint is she didn't die. I mean, that's pretty draconian at best. And but that was not made. He made his own decision as to what he entered into, and it should be denied, and costs should be awarded to my client to have to go through this process a second time. We've answered all the other extraneous stuff, and I think it's a pure retaliation for the reason that the defendant has been charged with domestic violence. He has a PPO coming up later. So this is striking back out, trying to retaliate. We ask that it be denied and that reasonable costs and attorney fees be awarded.
Okay. Anything else, Ms. Capture?
I have nothing further, Your Honor. The pleadings speak for themselves.
Okay. As the court reviewed this file in preparation for today, the court notes the court did state at the prior hearing that allowed defendant to renew his motion upon new facts, which would establish his basis for relief from judgment. I do not see any new facts in the current motion that would cause this court to vacate the judgment of divorce. There's nothing new from what was previously alleged. Court does not believe that the motion meets, again, the threshold necessary for relief from a judgment. And as a result, the court will deny that particular motion. However, the court does note that the motion does raise issues concerning parenting time. Parenting time is always subject to modification, and pursuant to Shade v. Wright, the court has a right to consider that, and that's a much less burden in this particular matter. The court will refer the issue of parenting time and support to the extent that the parenting time is changed and has an impact upon the support, and we'll refer that to the referee for a referee hearing. The court will not award cost at this time. Mr. Schaefer, you can prepare an order denying the motion to set aside relief, and then the court will prepare the order to send the issue of parenting time to the referee.
Thank you.
We are back on the record. It is Monday, September 30th, 2024 at 10:59 a.m.
Court will note that this matter is before the court on the defendant's motion to terminate the personal protective order in this matter. Only thing I would mention, Ms. Capture, as I was proofing and preparing this matter for today, your motion says see attached affidavit, and all the paperwork that I had from the clerk's office did not have an attached affidavit. So I'm going to need you to go into that because I have no idea what was in the affidavit.
Yeah, it's actually quite lengthy. Let's see. Yeah, it says we filed it, but it must have been. So I'm just going to read directly from the affidavit then, Your Honor, because it's quite lengthy, unless you want me to email it over to your office.
Nope, I'm not going to have opportunity to review it at this point if it wasn't done before.
It was filed appropriately with all of.
I understand. I just don't know where it broke down because I went back into the original motion and anything else, and there was no attachment. So
Okay.
So,
All
but
right.
you can address that when you address the testimony of your client.
Okay.
Unless you're just doing it through offer of proof, Ms. Cash.
No, I'll go through the testimony with my client. That's
Okay.
fine.
Do you have any opening statement to make at this point or not?
Well, yes, Your Honor, I just want to state for the record that this was filed appropriately within the 14 days. We do not believe that an ex parte order was justified given the fact that there was no immediate or irreparable injury present. There was no threatening. There was no behavior even set in the petition that would bring a reasonable belief that any of the prohibited acts under MCL 600-2950 would be issued. So, Your Honor, I would request that the ex parte be dismissed at this point. And then in the alternative, if we get through this and you believe that there is a reasonable belief that one of the prohibited acts are to be committed, that we at least modify the personal protective order to allow for communication for parenting time.
Okay, thank you. Mr. Schaefer, any opening?
Yes, I'll respond, Your Honor. There was a lengthy verified statement with the petition for the PPO that includes a substantial number of times, and the coup de grace was on August 26th when great bizarre behavior took place. That the respondent shows up at my client's home before light on one morning, and then would not let her out of the driveway, blocked the driveway, beat on the car, scared her and the children substantially, then tailgated her all the way to the school, taking the children in, which caused great angst in relation to the minor children and my client. It appears that there were statements made to him at that time that to the effect of run me over, and there's a history of mental illness here where back in at least in January of 23 that he was diagnosed with great anxiety to the point that he was suicidal at that point. The other events include August 1 at the Battle Creek Country Club, where he was yelling at her and following her at an event that the boys were at. There were events when he was brandishing a weapon with the children, and that dovetails back into the August 26th, where he was sitting out in his car loading magazines of a weapon. And he, in fact, did have weapons in the car that were found later by the police when he was stopped. This is disconcerting. It's bizarre behavior that is exacerbated over the time period. There are other events that took place in relation to him going into the home of my client without permission during a time period of him showing up at her home, going through the trash and looking for documents without permission. There was going back to even 22 that he had sexually assaulted her prior to the completion of the divorce. There is a myriad of problems here that justify the PPO, and we would ask that it be continued.
Okay, thank you. Ms. Capture, call your first witness.
Thank you, Your Honor. I'd like to call Mr. Scott Murphy.
Okay, Mr. Murphy, raise your right hand. We'll have you sworn in and we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay, go ahead, Ms. Capture.
Mr. Murphy, are you familiar with the allegations that Ms. Taft has brought against you regarding an incident on August 26, 2024?
I am.
And can you describe to the court what exactly happened from your perspective on that date?
I previously the night before wrote Kim that I would like to pick up the kids to bring them to school. And I suggested either meeting in front of her house or at the gas station or down the street from her house. And I got no response whatsoever via email or text that she would even allow me to pick the kids up, even though it was my parenting time. On the morning of, I left. I wrote her again, said, I'm on my way. Where would you like me to go? Again, I got no response. So I finally said, I'll be at your house, outside your house in about 15 minutes. Again, no response. So I parked outside on the street, waiting for her, because I didn't even know if she was going to give me my kids at that point. So then she came down. I saw her exit her driveway, her garage, and then she came out and walked down and started saying, you're not even supposed to be here. And I said, well, I didn't know where I'm supposed to go because you never answered my text, you know. And then she yelled at me that I need to leave, and then she was going to take the kids and not give them to me. So then that's when she tried to leave. I did block the driveway and then pulled forward, and then Ended up stopping the car. I got out and I asked her, I said, please, it's my time. I'd like to take the kids to school. And I was standing in the street. And then she drove the car up into me, right up against me, and was continuing to drive and move the car as I was against it. And I didn't say, run me over, run me over. She's yelling at me, move. And I said, I cannot move. You're running me over. At which point I finally moved. I rolled off the vehicle. She continued to speed off. The side mirror hit me as she passed me, which pushed it in. And as I was rolling, I hit the window where the kids were to try to help support myself so I didn't fall over, which was where the kids were, but I wasn't hitting it repeatedly as it said. And then I drove behind them, but it's on the same way to go to school. And I do have audio recording of that whole incident where I said, I can't move, you're running me over, to show that I didn't say run me over, run me over. And then I proceeded to drive. The kids called me and said that they didn't want me to take them to school that day. And I said, that's fine. And my route is the same route to go to school as it is for me to go to work. So I was behind them that way until I had to go to work and I turned right. But I didn't tailgate them the whole way. I was no more than 2 to 3 seconds behind them. Came to a stoplight at Territorial and Capitol Avenue. I stopped 30, 40 feet back. And I have dash cam footage of the whole drive to show that I was never tailgating her the whole way. And then I arrived to work. And then I was approached by police officers after that.
Ms. Taft states that you were, you had a weapon on you in your possession. Did you have a weapon in your possession? Was it within hand reach?
No, the weapons were in the back of the vehicle.
In the trunk?
Correct.
And you said that was your scheduled parenting time?
It was. I allowed the kids to stay the night at her house based on the agreement we had to try to help the kids transition into moving in with me and my wife on our time.
And was there a reason why you were loading bullets into a magazine?
Finnegan, my son, wanted to go to the gun range later that day. So I don't have a whole lot of time with them based on the parenting time and me giving them up to stay the night with their mom. So those take a long time to load. So I didn't know how long it was going to take for her to come out. So I was just trying to utilize time while I was waiting to load those.
At any time did you threaten Miss Taft?
Absolutely not.
Have you ever threatened your children with guns or Miss Taft with a gun?
Absolutely not.
Miss Taft talks about an incident on August 1st, 2024. Do you recall that incident?
I do.
And that was at a country club, correct?
Correct.
Can you describe what happened on that date and time?
They had just gotten back from a trip, so I hadn't seen them probably in close to a week. I had ordered water bottles for them that I wanted to give them. So I was on my way into work on a Thursday. They had camp for tennis. It's about noon. So I went in to go see them so I could hand them the water bottles. I was waiting in the car kind of to see if they had a break. Kim wasn't there at the time, but then she pulled up with her and her boyfriend. And they started walking in. And then it looked like the kids were getting ready to have a break. So I kind of walked in, but I tried to keep my distance behind her and him. But as I was walking in behind him, she says, not working on a Thursday, I see. Which I responded to like, not working ever to her. And then didn't really say anything after that. She went and sat. And I kind of waited in a different area. And then I saw the kids and hand them a bottle. And then I did say something to her like, it's ironic you say something to me about working when you don't work at all. And then she left the car and came back. I didn't follow her out to the vehicle or anything. I stayed in the little patio area there. And when she came back in, she asked about, or I told her that I had the country club membership changed to my name, which is what it is agreed to on the divorce agreement, that I have to maintain the family membership. And she said, why would you do that? You know, and I said, you're still able to take the kids in charge with the kids. And then she proceeded to call the kids over and say, we can't come to the country club now because dad took us off the membership. And I said, that's not what I said. You guys can still come. And then that's pretty much how that altercation ended.
At any time, did you follow her around?
Not at all. I stayed inside the fenced area the whole time.
Did you yell at her?
No,
Did you threaten her?
no,
And you were solely there for the purpose of seeing your sons?
correct.
On June 9th, 2024, were you still married to Miss Taft?
Stay.
June 9th, 2024.
No,
Okay. Do you recall an incident with your son at that on that date? Just as a reminder, she stated that the child claimed that you were brandishing a weapon or of some kind.
yeah, that's blatantly untrue because I didn't even own a weapon at that point. I didn't have my CPL license until July 3rd. So I had no fire gun or firearms or ammunition or anything in outside that apartment at any point.
On April 22, do you recall an incident between you and your son Finnegan regarding a Nerf gun?
Yeah, he was acting up, shooting his brother, shooting me. His brother asked him to stop. I asked him to stop. He continued to do it. He shot me. So I went and took it from him, grabbed it from him, kind of turned, put my shoulder into him and took it away from him. But I never slammed him into a wall or anything like that. And then he got upset and wanted to call his mom and go home.
Okay. At any time, did you threaten Miss Taft or show up to her home and act inappropriate in any way?
No,
Did you call her at all and yell at her or communicate with her in any way?
no,
Do you recall an incident that occurred on April 16th, 2024? Regarding the dog.
yeah. On the divorce agreement, it's supposed to be that the dog comes with the kids, but at some point, Kim just stopped following that part of the agreement and sending the dog with them. So I had taken the kids to try to get the dog, and they know the code to the front door, but they didn't. Apparently, she changed the code or it didn't work, so they couldn't get in. So I just suggested they go try a door around the side to see if that was open, if they could get in to get the dog. But I didn't even, I think I parked on the street for that. I don't even think I pulled in the driveway for that.
Did you instruct the kids to break into the house at all?
No, I just said to check that door if it was unlocked, if they could go see if they could get in and get the dog.
Okay. Did you enter the home at all?
No.
Did you attempt to enter the home
Not
at all?
I don't even think I got out of the car.
On August 14th, did you enter the house? Were you still married? August 14th, 2023. Sorry, that should say 2020.
Yes.
You were still married 2023?
Mhm.
So were you a joint owner of the home?
I believe I was
The
still
marital
deed until December.
Okay. Would you go over to the home throughout the year when you were still married?
Mm-hmm.
Okay.
She would have me over to help with things.
Did you stay at the home
Mm-hmm.
with her?
Sir, when you say would you say yes or no? Because it doesn't pick up and designate whether that's and whether it's
Yes.
yes or no. Thank you.
Yes.
Did Miss Taft during the course of the divorce proceedings at any time have exclusive use of the home?
I had moved out.
But was there any
But-
court order stating that you
No.
had?
There was nothing that prevented me from being at the house.
Okay. Had she ever told you, "I don't want you at the house anymore"?
She said she'd prefer me not to be there, yes, but
Okay.
not that.
But you would regularly go in
Right.
and out of the home. with her.
But I
agreement.
wouldn't go when she was not there.
Okay. There were some other allegations regarding your past relationship, of, inappropriate romantic advances on Miss Taft while you were still married. Do you ever feel like you, inappropriately advanced on Miss Taft during the course of your relationship?
No, I never tried to take advantage of her or willingly tried to violate her in any way. I
But you,
only,
you did engage in, marital relationships willingly with each other.
correct.
Ms. Taft did say something about you were accessing a trash can. This was, I believe, in January 2023, after the divorce was over. Did you access a trash can on the property at all?
Trash can was on the street. It wasn't on the property.
Okay.
So I did go through and trying to find out if the cancer diagnosis is actually real. So I was looking for a medical bill, but I didn't actually go on her property or take anything. And I spoke when the officer contacted me that she had called. He basically told me that I didn't break any law and be careful that she's just trying to get a case against you.
Objection, Your Honor.
Okay, sustained.
Mr. Murphy, have you ever threatened Miss Taft?
I have not, and I would not.
During the course of this divorce, you said that there's a pet involved. Did you ever try to take the pet and exert control over that in a way that would take away from her ownership interest in that pet?
No, I just simply I would ask her for her to send the dog with him, with the kids, and she would refuse.
Do you ever threaten violence on the dog?
No,
Do you ever threaten violence on the kids?
absolutely not.
Have you ever retained possession of the animal, or do you not get the animal at all
I
anymore?
don't get the animal at all anymore.
So she retains the possession of the animal despite the agreement between the two parties?
Correct.
It's my understanding that you have a concealed weapon license.
Correct.
Is that a condition of your employment at all?
No,
And you didn't receive that until July of 2024, is that correct?
correct.
Have you ever tried to remove the kids or any personal property from Miss Taft's possession?
No,
You've abided by any court orders that you have regarding the two?
correct. Even when she hasn't handed them over since this ex parte parenting time has been denied, she's still not giving my parenting time, but I'm not fighting him on it just to not cause a scene with the kids.
When was the last time you actually entered onto the premises of Miss Taft's property?
It would have been sometime early 2024. I was maybe on the driveway with the kids.
And are those entrances only for the purposes of exchanging the children?
Correct. Up until we started picking up at different locations.
Okay. And you've never threatened to show up at her home without her there?
No, I've said I can come pick them up at your house and she'll say no, but I've never said I'm going to be at your house without you there. Absolutely not.
Thank you, Your Honor. I have nothing further.
Yeah, thank you. Mr. Schaefer, any cross?
Yes, please, thank you.
Mr. Schaefer, we can hardly hear you.
Oh, okay, very good. We'll get up close and speak right up. All right. Let's go to the August 26th event. You had been told by your ex-wife that you were not to come to her home. Is that correct?
We agreed on meeting at different locations, but there was no court-ordered thing that I could not be there.
Okay,
But
well,
we had-
my question is, you were told by your ex-wife not to come to her home. Is that correct?
I was told that I was preferred not to be there.
And you understood that, did you not?
I had abided to it.
Okay, and you guys had agreed to a neutral spot of exit 92 for the exchange of the students, the children, correct?
For when it was time to exchange the kids, but not for, like, that would have been out of her way to do on a school day, and she wouldn't have done that on that day. So I was trying to get something that would be closer for her and more convenient for her.
And you never got her permission to go to her home, even though she had indicated that you should not go to her home,
I
correct?
never got anything from her because she refused to respond to anything. So I
Okay.
had no idea
And-
where to go because she wouldn't respond.
And she had indicated to you that the communication between the two of you should be by email, and you had communicated by email prior thereto, had you not?
We had communicated via text and email. And then when she gets upset, she would switch to communicating only via email, which I would communicate via both and then via email. But I communicated that I want to pick them up the next morning via email and via text, and I got no response to anything.
Okay. On August 26th, you admit that you blocked her drive and she had to go around you onto the grass to get away, did she not?
That's correct.
And you followed her so close that you were tailgating her for a long time period when she was taking the children to school.
That's incorrect. Like I said, I have dash cam footage that shows I was never more than 2 to 3 seconds closer than her the whole time.
And
And that's
at that time, it was dark out, was it not?
No, it was light. It was
light.
It was sunrise.
Did you have your lights on in the car when you were following her?
Probably the daytime running lights were on.
And the children, you said that you got communication from the children that they were afraid and for you, they didn't want to go with you, correct?
That morning that they said they didn't want me to take them to school that morning. And I said, that's fine. I understand. I'm sorry that I scared you guys. That was not my intention.
Okay. And you, in fact, pounded on the car of Kim's where the children were at the time that you got out of your car, did you not?
As I said, she was speeding by me and I was rolling on her car. She hit me with her side mirror and I was trying to maintain my balance and I hit the window trying to maintain my balance.
Why did you get out of the car?
Because I was trying to have her, I was pleading for her to let me have the kids because it was my time and she wasn't going to let them come with me.
And you had not exchanged the children at the home for some period of time, had you not?
Correct.
Okay. How many weapons did you have in the vehicle on August 26th?
There were 3 guns in the back of the vehicle.
And describe those to us, please.
One was an AR-15. The other was a H&K MP5. And the other was a Ruger, like a long handle pistol.
And you had gone through some mental difficulties and you had gone to life coach psychology, had you not?
I had just had a diagnosis done there, or a test done there.
And do you recall what the diagnosis was?
Just major depressive disorder and general anxiety disorder.
Okay. And
Mr. Schaefer, I can't hear you. We can't hear you.
okay, sorry. Excuse me. You had provided a report of the psychological review to Kim at some point in time, had you not?
Correct.
And that was by a Dr. Harold Smith.
Sounds correct.
And at that time, you had reported pursuant to a report of 12423 that you reported engaging in problematical impulsive behavior. Do you recall reporting that?
I have ADHD as well, so that would have been part of that diagnosis, but I don't know what I had told him. I mean, I took a whole series of tests, questions, so I don't know what they interpret off of that, so.
All right. And were you suicidal at that time?
No, I've never been truly suicidal. I had maybe thoughts at my lowest, but nothing that would have ever even been remotely close to following through with.
When you applied for your CPL, did you advise the authorities that you had been under mental care?
Well, I'm not any of those. I mean, I see a therapist. I'm not under mental care that way. So I see a therapist. Kim sees a therapist. So I don't think that's a negative thing. Everyone should see a therapist.
My question was, did you report that to the authorities at the time of your application?
No.
Okay. On August 1st, 2024, the country club event, did there not come a time when you were yelling at Kim?
I don't think I didn't yell at her. I may have raised my voice a little bit, but she always raises her voice when she talks to me. So it's just.
So you may have raised your voice because you were not seeing eye to eye about whatever subject matter that was there.
Correct.
Did you follow her when she had gone out to the car?
I did not.
Did you intercept her when she came back from the car?
I stayed sitting in that pavilion area, there's one entry and exit way out of that way. And when she came back in is when I told her that I had the country club situation taken care of, which she didn't appreciate. And then she twisted that into telling the kids that I kicked her out of the club and they couldn't go there anymore.
And what was your response when you heard that?
I told the kids that's not true, that they're allowed to come there and she's allowed to come there with them.
What
And
was
then
your response to Kim?
I just said that's not true. That's not what I told you.
In relation to the allegation on June 9th of 24, did you in fact, there come a time when Finnegan wanted to return to his mother?
There was 2 times that happened. I think that was the second time.
And if he reported that you had a loaded gun at that time pointing it around in your apartment, are you saying that's not true?
That's blatantly untrue. I didn't own a firearm at that time.
In relation to the April 22, 24 event at the Gethings Circle address, did you yell and scream at Kim at that point in time?
No, I mean, I was standing further from the car. I didn't go right up to her vehicle, so obviously I have to have my voice elevated so she can hear me, but I didn't yell and scream or in a threatening way.
And this was the time when you and Finnegan apparently had difficulty with a Nerf gun incident and the boys wanted to go with their mother. Is that correct?
Correct.
Okay. In relation to the April 16th, 24 event, when you were at the home of Kim's, you were present out there with the boys, were you not?
I was in the car.
Well, you were driving the car and you went to her location, did you not?
Correct.
Did you ask permission to go to her home?
I believe I wrote her and said that we were going there to get the dog.
You wrote her, how did you write her?
Text?
So you went to her home with the boys and you instructed the boys to go into the home, is that correct?
Correct. I asked them to go in and get the dog since she didn't provide the dog.
Did you ever ask Kim if you could do that?
I think I wrote her and asked her what the code was so that we could get the dog when I was there outside.
And did she give you the code?
She said that the door was broken or something. I don't know. Made some excuse. That didn't work.
And so for whatever reason or interpretation, she never gave you permission to take the boys and enter the house.
Correct. Well, she just never gave me the code. She didn't say yes or no.
Okay.
I don't remember.
On January 18th of 24, you admit that you appeared at her home and went through her trash. Is that correct?
On the street, correct?
And you did that because you didn't believe anything about her diagnosis and you were looking for those papers. Is that correct?
Correct.
Did you tell her that you were going to go to her home and look through her trash?
No.
In August 14th of 23, did you go into the home where Kim was living without her permission?
I don't believe so.
Isn't it true that you had gone into her home a number of times without her permission?
I don't think that's correct. We usually only go there when she was there.
In reference to an event of January 12th of 2022, did you inappropriately sexually assault Kim?
I don't see it as an assault. I was consensual at my time. To the best of my knowledge, there was an incident a couple days before that was consensual as well, so I thought I was well within my.
Okay, regardless of the prior consensual one, you got complaint from Kim about this sexual activity that you forced upon her on that date. Is that not true?
She may have said no, but she would often, anytime we would have any kind of relationship, she would always start out by saying no.
She
So it's
was
hard.
she was quite ill with COVID at that time, was she not?
She was sick, what I know.
And you emailed her shortly thereafter, and you admitted that you overstepped your bounds in that time. Did you not?
No,
And didn't you email to her? I wasn't trying to take advantage. I was just trying to make you feel good. I should have stopped. I'm sorry. I won't spin it. I was wrong and I'm sorry. Do you recall emailing that?
I believe it's a text, but it wasn't admitting to any kind of wrongdoing.
Do you admit that you text that message?
Yes.
Okay. No further questions this time, Your Honor. Thank you.
Thank you. Anything else, Ms. Capture?
Mr. Murphy, when was the diagnosis given? That was in January 23, correct?
That sounds correct.
And that was before you and Miss Kimberly Taft were divorced, correct?
Correct.
And since that diagnosis, have you been engaging in therapy?
I go weekly or bi-weekly.
And do you have any medications prescribed to you?
I do.
And do you take those medications as prescribed?
I do.
And at any time, do you feel like you were a danger to the community, or does your therapist believe that you were a danger to the community?
Absolutely not.
I'm going to object to the opinion of the therapist, General Behusa.
I will sustain that.
And were you required under your CPL to state that you engage in therapy?
No, I don't believe it asked that question.
Okay. Again, throughout this entire period, obviously there was a contentious divorce. Is that a correct statement?
Correct.
And then there's also contention, to your understanding, post-judgment. Is that correct?
Correct.
Is it your understanding that there's primary contention regarding parenting time?
Correct.
How would you characterize yours and Miss Taft's relationship now?
Obviously very non-existent. I only want to contact her regarding the kids and pick up time and whatever needs they might have. I don't have any desire to have any kind of other relationship with her. I just want to be able to see my kids and be at their sporting events. And, you know, I help coach my youngest son's baseball team, and for this, I go to all their sporting events, and I can't go to them now. And it kills me to not be able to go to do that. I would never, prior to this event, anytime in public, there was never any kind of scene with us. I've never once threatened her violence. I wouldn't ever threaten violence or do violence against her, because I wouldn't hurt the kids in that way or her in that way. And it's just not worth it for me to have something happen, so.
Thank you, Honor. That's all I have.
Thank you.
If I may
Yeah,
respond, a
wait.
couple questions.
No, I don't need any more. Ms. Capture, do you have any other witnesses?
I have no further witnesses.
Okay, Mr. Schaefer, do you have any witnesses?
I would call my client to the stand.
Okay,
Raise your right hand, be sworn.
Okay. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
go ahead.
Okay, Kimberly, speak right up. You've got quite a ways away, so kind of yell at me here so everybody can hear, okay?
Okay.
All right. You had made a lot of allegations in relation to your petition for a PPO, correct?
Correct.
And were those allegations true at the time that you had filed this petition? And let's go down through the last one, the August 26, 24 event. Tell me what happened on that particular day.
It started the night before, when the kids were going to come back to me that evening. Scott sent me an email, letting me know that he would not be bringing the kids to exit 92, which is where we normally did the exchange, that he would be at 88. And I replied back that 92 is where we had always been. That's where I felt comfortable, because it was a public place. There were a lot of people. The exit that he wanted to meet at is desolate. There are no people around. There's no business around. It's just an empty lot, which made me uncomfortable.
What happened on the morning of August 26th?
That morning, when I was getting the kids ready to go meet Scott, I noticed that he was sitting in front of my house. I decided to walk down and ask him why he was there. When I got to the car, he was loading gun magazines. I asked him why he was at the house, and he stated because he could, and he was there to pick up the kids to take them to school. And I said, you know that you are not allowed here, and I need you to leave.
Had you told him not to be at your home prior to this date?
Yes, repeatedly.
And was there any question in your mind that that message had been sent to him that he was not to be at your home?
He knew that he wasn't allowed to be at the house.
And your agreed to exchange neutral place was exit 92, not exit 88?
Correct.
And so what happened in the morning Did he leave at that time?
He did not leave. I asked him why he was loading the gun magazines. He responded, I can do what I want. I have my CPL. I responded back, no, you can't. You are scaring me and you're trying to intimidate me and I need you to leave. At that time, I walked back up the driveway. Scott was yelling at me from his car. I got into the garage. The kids had come out of the house and gotten into the car. They wanted to know why Scott was there.
Okay, so you got in the car and did you try to leave your home at that time with the kids?
I backed out of the garage and drove down my driveway. And at that point, Scott pulled up his vehicle to block me from leaving the driveway. I then turned right into my yard and started to drive through the grass to be able to leave. He pulled up and sped up, so I couldn't. He drove me further into the grass. I eventually stopped quickly and was able to slowly try to maneuver myself around his vehicle. And at that time is when he jumped out. He started yelling at me to give him the kids. I told him he was scaring us and to move out of the way. I continued the whole time to inch forward. I was scared. And at one point he moved to the passenger side of my vehicle. He hit my side mirror, made it fold in, and then he started hitting the window where the kids were sitting.
What was the reaction to the kids at that point in time?
Fitzpatrick, our 10-year-old, started asking, what is he doing? He's a psycho. And Finnegan, our 12-year-old, said, what is wrong with him? Why is he doing this? And I said, I don't know. And
Did you eventually leave your property?
I did.
And did you get followed by Scott at that point?
I did.
And how far did he follow you?
All the way to the light at Territorial and 20th Street.
And how close was he traveling behind you?
When he began to follow us is when I called 911. And at that point, I was focused on driving and talking to dispatch. Fitzpatrick, our 10-year-old, is who said while I was on the phone with dispatch, why is Dad following so close? He's
Objection, Your Honor.
Okay,
Hearsay.
tell us what somebody else said. What did you observe? How close?
I observed at that point on 6.5 Mile Road that he was following extremely close to my car.
Okay, did you feel that he was tailgating you at that point?
Yes.
Okay, the next event that we allege is August 1 at the Country Club event. Tell us what happened on that date.
Dropped off the kids at their tennis lessons. I ran a quick errand and came back. When I came back and parked and began to walk into the facility, Scott got out of his car and followed behind me. I made a comment that I was surprised he wasn't at work at noon on a Thursday, which is one of the busiest times for our restaurant. At that point, he got loud and began to degrade me.
What did he say?
He told me that I needed to get a job, that I was worthless.
All right, and so was there more? Did he follow you any other time at the event?
Yep, I went and sat the furthest spot away from him. But after a few moments, I noticed that Finnegan had forgotten his baseball cap. So I went to go get it. The only way out from where I was sitting was to walk past Scott. At that point, he got up, began yelling at me, and followed me all the way to the parking lot. I went to the car, got the hat. I came in around a different way and tried to give it to Finnegan and went and sat further away from him.
Okay. The next incident we had, you on June 9th of 24, did you get a request to pick up Finnegan from Scott's place?
Yes, I did.
And was he distraught, Finnegan distraught when you picked him up?
Yes, he was crying and very upset.
Okay. And the next incident is April 22 of 24. And that's at Gethings Road. And had something to do with an altercation about a Nerf gun. Do you remember that incident?
Yes.
And did you get a call to pick up Finnegan and Fitzpatrick at that point?
I did.
And how were you treated when that happened?
When I arrived, Finnegan came out first alone. He was crying. He was afraid that Fitzpatrick wouldn't come with him as well. he went back inside to get him and his stuff. And at that point is when Scott came out. I never got on my vehicle. I had my window down. He began to yell at me that this was all my fault. He was screaming at me that I did all of this. This is my fault. He repeatedly kept saying it over and over. He eventually went back in the home, in the apartment. I could hear him yelling at the kids. A short time later, the kids both came out crying and got in my vehicle.
Okay, the next incident is April 16th of 24, concerning the dogs at your house. Tell me what happened in that regard from your perspective.
A lot of times due to the children's sports, the exchange of the children would be done at their sports, which would mean I would not have the dog. He would, whenever he decided it fit his schedule, would then try to make plans to pick up the dog. On this particular day, I knew that they were at the house trying to get in because my Ring doorbell went off. And at that point, I called Scott on the phone and asked him why he was at the house, why he was trying to get into the house. And he stated that he was trying to get the dog. I told him, as stated before, you're not allowed at the house, and the children aren't allowed at the house during your parenting time when I'm not home, and that he needed to leave.
What did he say to that?
I don't recall exactly what he said, but I had to state to him that if he didn't leave, I was going to call the police. And it was during this time where he had told the kids to go try to push through a door in my garage. This made me feel unsafe. I ended up having all of the locks changed again, which I had already had done after we separated, and now had done it again because I was afraid that he was going to come in the house.
Okay, and next incident is January 18th of 24.
Mr. Schaefer, I don't want to cut you
Yes.
off, but we're going long, and I've got a number of other hearings, and I think I've heard sufficient that I need in this matter.
Okay, very good.
So I'll let Ms. Capture go into any cross before we conclude.
Thank you, Your Honor. Ms. Taft, on the morning of August 26th, did you ever communicate with Mr. Murphy?
No.
You never sent him any text messages confirming that your location was going to be the typical exchange location, even though he asked you multiple times?
He sent an email to me stating that he would be at Johnny's near my home to pick up the children.
Did you explain that you would meet him there?
No, I tried to call him on the 25th after that email, and that is when he hung up on me. I tried to call him again, and he didn't pick up.
So it's your typical understanding that you communicate via email?
Yes.
And you refuse to communicate with him via email about parenting time exchange?
The conversation went from email to over the phone on the 25th. He stopped responding to me. He wouldn't take my call.
And you did not communicate with him via email on the 25th at all?
I did communicate with him via email on the 25th. It then led to a phone conversation, which started, he hung up on me. I tried to call him back. He didn't pick up.
But you did not confirm, again,
that.
you did not confirm that you would meet Mr. Murphy at the location that he emailed you?
I didn't reply to his email. I called him.
Thank you. Did you respond to any of the text messages in the morning that he sent to you?
I don't get his text messages, which he's known for quite some time.
So you co-parent with Mr. Murphy, but you do not communicate with him via text, even though that is something that he communicates with you on, because you blocked him, I'm assuming?
We stopped. I told him that I did not want to communicate via text anymore because he would obsessively text me over and over and over again. So we moved over to email.
And it's my understanding that you did not email him in the morning. I'm sorry, Ms. Taft. Just to clarify, you did not email him in the morning on the 26th?
I emailed him on the 25th.
Okay, but you did not email him on the morning of the 26th, correct?
I do not believe so. I emailed him on the 25th.
And what did you state in that email on the 25th?
It was regarding the pickup spot.
For the morning of the 26th?
No, for the 25th, for him refusing to go to our pickup location.
Okay, so you did not communicate with him at all about the exchange on the 26th?
No, because he wouldn't pick up the phone.
Okay. Ms. Taft, you talk about the altercation at the country club. You were the person to instigate the conversation with him about his work schedule on Thursday. Is that correct?
I made a comment to him, yes.
And you stated that he followed you in. What time was that at?
Roughly 12:30. I don't know for sure.
And was that around the time the boys were taking their break?
Not at that time yet.
But it was roughly around that time.
I don't recall what time they took their break.
Has Mr. Murphy ever in the last year threatened to physically harm you?
He has repeatedly put himself in situations that have felt very threatening to me.
But he's never threatened to harm you.
On the day of the 26th, by him sitting there and repeatedly loading gun magazines after I asked him to stop and I told him I was scared. Yeah, I felt that.
Maybe I can rephrase to help you. Has he ever verbally threatened to harm you?
He said he could do what he wanted that day. So yeah, that was a threat to me.
Was that, okay. Did he have a gun in his possession that you could see?
There was a case, that's all I could see, but I was too focused on the fact that he was filling gun magazines throughout our entire conversation. It never stopped.
Okay. Your Honor, I have no further questions.
Okay, thank you. I don't need any more, Mr. Schaefer.
Okay.
Ms. Capture, any closing?
Your Honor, the code is very clear. To be able to satisfy, you need a reasonable belief that an individual will commit one of the sections under 62950. The last time Mr. Murphy entered or allegedly entered the premises was back when these parties were in the midst of a separation. He's never assaulted, attacked, beat, or wounded Petitioner. He's never threatened to kill or physically injure her. He's never removed the children from her except by custody and parenting time order. He is allowed to purchase and own a firearm. He has a CPL. Loading bullets into a magazine is not the same as threatening. It is not loading it into a actual weapon. No weapons were in his possession at the time, well, within his hand reach. They were in the trunk of a locked vehicle. Respondent has never removed personal property from the premises that are solely owned by Petitioner. He's never showed up to her place of employment or education to interfere with her. He's never sexually assaulted her. He's never removed access to minor children's records or removed any access from Petitioner records whatsoever. He hasn't tried to exert any control over Petitioner with regards to animals. He's never injured or tortured or killed an animal. He's never even removed the animal, even despite the fact that Petitioner doesn't follow the agreed divorce consent judgment. The problem here is that these parties are engaged in a very tumultuous post-judgment divorce proceeding. There is numerous complaints that this has to do with parenting time. Most of the allegations have to do with parenting time. The parties don't agree, they don't see eye to eye, and this needs to be resolved in family court, not in a PPO. This is only further ammunition for Ms. Taft to continue to make a wedge between the children and Mr. Murphy. There's no basis at this point for a PPO. What needs to happen is these parties need to engage in co-parenting therapy. That's obvious. However, lack of communication is a strong indication that the two parties don't want to co-parent. Changing communication on my client to be able to pick up his children, that's an issue. One moment petitioner will engage in texting, next moment she'll phone call, the next minute she'll email. That's inconsistent and it causes confusion, which causes disruption, which inevitably causes arguments between co-parents. This is not a PPO situation. This is a failure and breakdown of co-parenting. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, this certainly is a PPO situation. The actions of somebody who is going through therapy currently, apparently, and back in 23 diagnosed with some mental illness and shows up at my client's home unannounced, without permission, loading magazines of guns at 7 o'clock in the morning, is disturbing at best. Admittedly, not only did he have handguns, he had AR-15s in his trunk. When the nicety of it, not in my possession, not in my reach possession, but in his possession, is disturbing at best. We have heard too many stories the next morning of improper use by mentally ill people. That is problematical. We have heard testimony that there was a sexual assault, admittedly so, that he overstepped his bounds. Heard that he has been to her home without permission, whether it's to get the dog or coerce children to go into the house. This is problematical. We have heard yelling and screaming and threatening at country clubs at times when they are exchanging children. This is a PPO situation that needs to continue on for the safety of my client, and I would so request. Thank you.
Okay, thank you. Well, in this particular matter, the court and the attorneys have noted, and they've referenced MCL 600.2950. Particularly, the court can enjoin and restrain certain conduct if the court determines that there's reasonable cause to believe that an individual has committed or may commit any of the acts listed under MCL 600.2950 parens 1 parens A through K. There's been a lot of testimony, probably a lot more than the court needed in this case, about somewhat tenuous circumstances and times when they were still together. I don't infer or ascribe anything to the respondent in this matter when he entered the home at the time when they were still married and the home was still effectively at that time both parties had access to it. There were other things as well. However, the court does note there was testimony and that was corroborated and affirmed by the respondent that on the occasion back on August 26, 2024, that he pulled into and did block the driveway of the home where the petitioner and the children were attempting to leave. Different interpretation of the events that ensued, but notwithstanding that, he did block the driveway. He noted as well that on a date that he was in the vehicle, his vehicle, and I think it was a different date, but it sounds like it was the same date, that he was loading the magazines for a gun, and he didn't have the gun present. He had the again, the magazines and apparently the bullets, and he was loading that. Court will find in this matter that, again, in pulling into and blocking the driveway, making her go out into the yard, was, in fact, subsection A, entering upon the premises the court will find that, again, the situation of loading bullets when the other party is present and then stating, well, I can do what I want, would characterize an activity under sub K, other act or conduct that imposes or interferes with personal liberty or causes a reasonable apprehension of violence. Again, a lot of the things in this case, as interpretation, was the person yelling? Were they not yelling? Were they raising their voice? Things of that nature. But again, these two instances that the respondent acknowledges would fall into the parameters of placing a person at reasonable apprehension, again, in this particular case. As a result, the court does believe that it is appropriate that the personal protective order continue. The court would make I guess you'd say, a amendment to that, which would allow the respondent to contact the plaintiff vis-a-vis email, because apparently that's what they were using for purpose of, or basically for specific child-related matters and for issues of parenting time. So the petitioner, oops, we lost.
I think we lost Mr. Schaefer.
Yeah, we lost him.
Maybe he didn't like what I was saying at that point. So the court will continue the personal protective order, but allow the contact for purposes of specific child-related matters and for parenting time. So Mr. Murphy, you can contact her by email for those purposes, but those purposes only. So don't go outside the realm of that. Don't call her with the idea that you're going to discuss a child-related matter, then get off on tangents on other things, because that would be a violation. But the court would allow you to, again, address child-related matters. For instance, the children were sick, or school activities or things of that nature, or for parenting time, and that's it. So the court will make that modification. We'll get that entered and out to the parties. So you're free to go. Have a good day.
Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill. Based on her representations to Mr. Murphy would be dying within the year. Now he is being told by her numerous friends and family that she is not in fact terminally ill, nor was she ever terminally ill.